Ever heard of a killer? I drop bombs like Hiroshima.
Somebody said, look at LeakYou video. What the fuck is LeakYou? Is it like a site? What's LeakYou? LeakYou. Is it a YouTube channel? Oh, shit. Oh, all right, bet. Here we go.
Please hit the like. Thank you.
One, two, three, four.
Good morning, good afternoon, good evening, folks. We are back for additional information. And as the title says, FreakOffs, arson, drugs, kidnapping, IV fluids, and over 1,000 bottles of baby oil and sex lubricant that was confiscated by federal authorities. As you all know, Sean Combs, aka Diddy, no Diddy, has been charged with multiple charges, including sex trafficking and racketeering. He's been hemmed up with the RICO Act, and he is going to be fighting for his life. And what I want to talk about right now is the latest. And then I don't even know if we'll have time as we go through the latest, but before this night is out, we will be talking about the civil lawsuits that had a lot to do, I think, with Diddy being charged. All right, but here's the latest. Right now, lawyers are in a courtroom fighting to try to get Sean Combs, aka Diddy, out on bail. Prosecutors do not want Diddy to receive bail. They want him remanded. And we're going to talk about the bail package that defense attorneys have offered. Okay. But the latest here is that Diddy, Sean Combs, has pled not guilty to all the charges against him, which we fully expected. This embattled mogul made his initial appearance in federal court this afternoon in Lower Manhattan, where he entered that not guilty plea, again, as to be expected. But the more pressing issue right now for Diddy was whether or not the judge is going to allow him out on bail. Now, Diddy, Sean Combs, offered to fork over a staggering $50 million as bond. Now, he wouldn't pay that amount in cash. Instead, he offered up his $48 million Miami mansion and his own mama's home as collateral, and said he was willing to wear a GPS monitor and to limit his travel to South Florida and the New York City area. Now, the court hearing, again, is still ongoing. The judge has yet to rule on the issue of bail. If convicted, of all these charges, Diddy is facing a minimum sentence of 15 years and a statutory maximum of life in prison. So the stakes are incredibly high right now. Prosecutors believe that Diddy is a flight risk, and they don't want him out on bail. But Diddy's attorney has taken on a new narrative that the rap mogul Diddy is, this whole narrative about him being a brute and a bully. Oh, you all, he's trying to come at Cassie now. This is very interesting. The attorney is hinting that there's more to the story regarding the 2016 hotel hallway incident involving Combs and then girlfriend Cassie. The video went viral as soon as it was dropped of him beating Cassie. But listen to this. Diddy's camp, including his attorney, argued that victim one, remember when we read the indictment earlier, I told you I believe victim one is Cassie. And I think this is going to reiterate that for you all. Diddy's camp is arguing that victim one had been looking through his phone and discovered that he had more than one girlfriend, and then hit the rapper in his head with a cell phone and took off with his clothing, which lawyers feel explains why he was in the hallway in a towel in the footage that surfaced back in May. I didn't see any clothes in Cassie's hands. He came behind that girl and threw her down and was wailing on that young lady. But defense attorneys are already attacking Cassie, claiming that she actually attacked Diddy, hit him in the head, took off with some of his clothing. Now, his lawyer also claims that Diddy and the unnamed victim, officially unnamed victim, which we do assume to be Cassie, was very much in love until Cassie cheated for years, quote, for years, end quote, with a trainer that the A-lister that Diddy had provided for her. The disrespect, the absolute disrespect. So he's basically calling Cassie a whore. She cheated on Diddy. I mean, all of these things, but I know what we did see with our own eyes. We seen a man assault the shit out of Cassie, choking her out, all kinds of stuff, man. Has no control of his emotions. Now, Cassie notably did marry physical trainer Alex Fine in September of 2019. They actually have 2 children together. Now, Diddy's lawyer is claiming that his client is not a, quote, perfect person, but has found himself in toxic relationships, but claims that the relationships were mutual. However, earlier in court, it was suggested that Diddy had wrote a large check to an ex for 10 years, but it's unclear who received the payment and for what reason. Now, prosecutors have been busy laying out their case for denying Diddy's bail. And they say that they're worried he will intimidate witnesses and obstruct the case if he's released on bond. And what's more is the feds say the witnesses they've interviewed have universally expressed fear. And prosecutors claim Diddy called his former artist, Kalina Harper, 54 times the day before she made a statement about a recent lawsuit that they were named in. Prosecutors also say Diddy's got the money and the means to be a flight risk, even though his passport has been, taken from him. It's been remanded. It's being held by federal authorities. Now, here's something else. Here's some more tea for you. When the feds arrested Diddy last night, they found what appeared to be narcotics in his hotel room. The feds say there was a pink powder that tested positive for ecstasy that was found in Diddy's hotel room, as well as other drugs. So it appears Diddy has a personal issue with drugs, which is absolutely no excuse whatsoever. Now, I want to give another shout out to my anonymous source, all right, who managed to get for me 2 letters that I'm gonna show you here. One of the letters was submitted to the judge from his attorney, and the other letter was submitted by the prosecution to the judge, who does not want Diddy to get bail. And we're going to take a look at them right now. Okay. Let's go with the letter from Diddy's lawyer first. All right. This is the letter that was submitted to the Honorable Robin Tarnofsky, United States Magistrate Judge in the Southern District of New York, by Sean Combs' attorney today. This is again in regard to the United States versus Sean Combs. Dear Judge Tarnofsky, Mr. Sean Combs, through his counsel, submits this letter to the court for release on certain specified conditions. Yesterday evening, Mr. Combs was arrested on an indictment charging him with the following offenses. And these offenses are listed by their title number, okay? And if you check my video previously, we went through the full indictment, and you'll be able to see what those offenses are. But what it comes down to is prostitution, racketeering, and the RICO charges, and some of the additional allegations, kidnapping, arson, guns, drugs, and not to mention IV fluids. These freak-offs that Diddy would have, these elaborate produced freak-offs that were also filmed, were so physically intense for Diddy and the victims that he had medical IV medication and equipment on deck to recover. He had to be an intravenous line had to be given to him so he could recover from these freak-offs that would sometimes last for days. And it's not just Sean Combs who got these IV fluids. Some of his victims also received these IV fluids. Now, this letter goes on to say, for the reasons set forth below, we ask this court to release Mr. Combs pursuant to our proposed bail package. This letter will walk the court through a series of actions taken by Mr. Combs over the past 6 months that prove that he is not a risk of flight or a danger to anyone in the community. These actions prove that Mr. Combs is eminently trustworthy, and he is demonstrably committed to showing his innocence in court in the context of this case, and that he should be released on the conditions proposed in order to do so. Again, this is a letter from Diddy and his attorney, okay, to the judge. The first thing the court should know is that when it became apparent to his counsel that Mr. Combs would at some point soon be formally charged, he did something extraordinary. He left his home in Miami and traveled to New York, the very location of the prosecutors and agents investigating him. Through counsel, Mr. Combs promptly told the government that he had voluntarily come to New York offered to tell them specifically where he was and offered to turn himself in at the appropriate time. See, Sean Diddy, he wanted it his way. He wanted to, he wanted to do it like the mob bosses do, right? They turn themselves in on a certain day. Even though Mr. Combs came to New York, authorized his lawyers to tell the government of his location, and offered to self-surrender, the government effected an arrest last evening. This, we know, is the government's right. However, that he traveled to New York to self-surrender is also something the court should consider. This was not the first action Mr. Combs took to show his trustworthiness and lack of flight risk. Indeed, it is a part of a pattern since even before the March 25th, 2024 searches on Mr. Combs's residences. Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking and other offenses. Knowing for these many months that he would be indicted, Mr. Combs has done everything, as will be set out below, to work with the prosecutors in ways that are unusual, if not unprecedented. Now, have we forgot how Diddy denied that he ever put his hands on a woman, that he ever beat Cassie up, and then that video dropped and he had to eat his words? And then he came out and gave that real shitty apology. But remember, his previous statements that he had made, that he was innocent of what he was being accused of, but then that video dropped. In light of these circumstances, he can rebut the presumption of detention here due to his extraordinary actions in this investigation. Mr. Combs should be released on the conditions proposed so that he can fight this case in court effectively. The proposed package. This is what Diddy and his lawyer have proposed to Judge Tarfosky. A $50 million bond, co-signed by Sean Combs, his mother, his sister, the mother of his oldest daughter, and his 3 adult sons. Basically, he's putting his whole family on the line for him. Secured by the equity in Mr. Combs' residence located at 2 West Star Island in Miami, Florida. That A, the appraised value of the home is about $48 million. B, the home is unencumbered. In anticipation of this bail hearing, on August 20th, 2024, Mr. Combs paid off the remaining mortgage of about $18 million so that the home could be used to secure a bond and be free of a mortgage. So if anyone's wondering if Diddy anticipated this arrest, I think you all are starting to realize he knew his arrest was coming. He knew this day was coming. Secured by, Mr. Combs, secured by the equity also of Mr. Combs's mother's home, located at 450 Alton Road in Miami, Florida. Now, it's crazy enough that he's offering up his own home, $48 million, but dang, you're going to offer up your mama's home too? Because Diddy is a selfish person. The only thing that matters to Diddy is Diddy. And I hear he doesn't treat his mama all that great, by the way. Now, Mr. Combs' travel will be restricted to the Southern District of Florida and the Southern District of New York to attend court, meet with his counsel, and attend medical appointments, which we will address to the court in a separate sealed submission, as well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. Mr. Combs' passport was surrendered to his counsel on April the 1st, 2024. His counsel advised the prosecutors of this fact in an email dated the same day. Counsel will provide this passport to pretrial services. The passports of the following family members who have already surrendered their passports to counsel after the raids on Mr. Combs' homes: Janice Combs, Chance Combs, Jesse Combs, Delilah Combs, and Love Combs. Since at least April 2024, Mr. Combs has been making efforts to sell his airplane. We informed the government of these efforts in May 2024, as explained further below. Just this weekend, Mr. Combs entered into a letter of intent with a party to sell it. Mr. Combs understands he is not to travel to Los Angeles, where the plane had been located this week, and further that the plane is not to be brought to any district in which he is located until it is sold. Home detention with GPS monitoring, and all other standard conditions of pretrial supervision. Now, the letter goes on with a bold subtitle here. The history of this investigation shows a great degree of collaboration between the government, Mr. Combs, and his counsel, which should weigh heavily in this court, releasing him on the conditions proposed. On March 13th, 2024, counsel for Mr. Combs emailed the assigned assistant United States attorneys. In this introductory mail, counsel identified himself as counsel for Mr. Combs and stated that he wished to speak with the prosecutors and share information about Mr. Combs and the matters under investigation. After not hearing back from the Osas, counsel again emailed the prosecutors on March 18th, 2024. Counsel did not get a response to this second email either. On March 25th, 2024, search warrants were executed at Mr. Combs' place of residence in Miami and Los Angeles. In addition, he was removed from his airplane and searched. The searches of the residences were unusually public and particularly heavy-handed. The agents had assault rifles trained on the heads and chests of his children, who were then handcuffed and brought before news cameras and a press helicopter. On the day of the searches, counsel called the prosecutors, and they spoke for the first time. Counsel indicated that he would accept service of 2 grand jury subpoenas to Mr. Combs' businesses. 1. Counsel took possession of Mr. Combs' passport on April the 1st, 2024. About a week following the searches on April 1, 2024, counsel took possession of Mr. Combs' U.S. passport. As noted on this same day, counsel advised the Osas of the fact that counsel had Mr. Combs' passport, that we would not return it to him, and that he would not leave the country during the pendency of the investigation. We have, in fact, maintained the passport, and Mr. Combs has not, in fact, left the country, despite knowing the investigation was ongoing, despite having a plane at his disposal, despite not being charged with any crime. Now, noted here is, as of this morning, meaning this morning, the 17th of September, the plane is in Teterboro, New Jersey for a charter flight. 2. Counsel agreed to advise the government of all domestic travel. See, now we're starting to see the crunch that Diddy's been in. All these things were happening behind the scenes, so to speak. They're just now becoming public. Diddy absolutely knew this was coming. Moreover, Counsel advised the government that if Mr. Combs intended to travel domestically, counsel would so inform the Ozas, mainly the attorneys, the prosecution, right? These two promises have also been kept. For example, on June 9th, 2024, counsel advised the Ozas that Mr. Combs was traveling from Miami to Los Angeles to go on a road trip with his children. Well, he could have found himself in Mexico in that road trip, right? But again, he wasn't under arrest back in June. So all this, they were trying to make it look like he's absolutely, collaborating or working with the federal authorities. And as you heard Damian Williams say in the presser, his version of the word, collaborating or working with the prosecution means something entirely different to him versus what's being said from Diddy's side. In addition, we provided the Ozas with information about when his flight departed and it would land. On June 29th, 2024, counsel emailed the prosecutors that Mr. Combs was flying to Wyoming via a chartered aircraft. On July 5th, 2024, counsel emailed the prosecutors that he was traveling back to Los Angeles. 2 days later, on July 7th, 2024, when he traveled back to Miami via a chartered aircraft, we again emailed the Ozas. In addition, when Mr. Combs planned travel but not take those trips, we notified the prosecutors of that as well. Don't you find that odd that he would be telling all of his travel with the prosecution and he hasn't even been charged yet? 3, counsel advised the government of Mr. Combs' efforts to sell his private airplane. You know, the one he's so proud of. On May 21st, 2024, counsel advised during a phone call that Mr. Combs had commenced efforts to sell his airplane. We followed up on that conversation the next day, on May 22nd, 2024, with a letter to the Ozas that efforts were underway to sell the aircraft and reminding that counsel continued to be in possession of his passport. Over the past several months, there have been several potential buyers for the airplane, and at least 2 buyers have signed a letter of intent to purchase the aircraft. Just this weekend, a buyer for the aircraft and representatives for Mr. Combs executed a letter of intent. Due to the nature of this asset and the amount of inspection and due diligence that is required for a purchase, it is not a simple asset to offload. In advance of the plane being sold, which it eventually will be, but it still hasn't been yet, right? Yeah, they said they already had 2 letters with a letter of intent to purchase the craft, but again, it still belongs to Sean Combs. We have agreed to keep the airplane in Los Angeles while Mr. Combs resides in his home in Florida. If it is not being chartered, coincidentally, and not at Mr. Combs' request, last night the airplane was chartered on a Part 135 flight from Los Angeles to Teterboro, New Jersey. Mr. Combs had no advance knowledge of the flight, nor did he possess any control over its movement last night. Obviously, Mr. Combs agrees to not go to any state, in this case, New Jersey, in which his airplane is located, pending its sale, which is actively being pursued. 4, Mr. Combs voluntarily relocated to New York in advance of his arrest. Once it became apparent to counsel that Mr. Combs' arrest was imminent, he promptly relocated to New York City. On September 5th, 2024, Mr. Combs arrived in New York, and counsel immediately informed the government of Mr. Combs' whereabouts. Counsel offered to continually share Mr. Combs' location with the government. Since arriving in New York on September 5th, Mr. Combs has been staying at the Park Hyatt, New York. Due to bookings made at the Park Hyatt prior to Mr. Combs' reservation, after today, September 17, 2024, he would no longer be able to stay at the Park Hyatt. Accordingly, Mr. Combs had a reservation to stay at the Carlisle Hotel starting today. Since Mr. Combs relocated to New York earlier this month, counsel has been looking for a 1-month rental for Mr. Combs in New York City. Despite counsel's persistence, it has been challenging to find a rental for many reasons, including because of the numerous events occurring in New York City in September, example, the US Open, Fashion Week, and the UN Summit, and some landlords' discomfort with having Mr. Combs as a tenant given the investigation. Last night, counsel had scheduled a viewing of a potential apartment. However, because of Mr. Combs' arrest, counsel and Mr. Combs obviously were not able to view the rental. 5, counsel advised the government that it was in possession of the passports of members of Mr. Combs' family. On June 13th, 2024, counsel informed the government that we possessed Mr. Combs' mother's passport. We have also informed the government that we possessed the passports of his 4 daughters, all of whom were minors at the time we took possession of the passports. Now, 6, counsel's assistance to the government concerning the subpoenas. As stated above, counsel accepted service of 2 subpoenas directed at several of Combs' businesses in March of 2024. Separate counsel for the entities filed a motion to quash those subpoenas in April of 2024. In May of 2024, upon becoming sole counsel in connection with the criminal investigation of Mr. Combs, we advised the court that it would withdraw the motion to quash the grand jury subpoenas, and instead that the parties would meet and confer with the government to minimize the number of requests on which the parties disagree. Counsel agreed to begin gathering documents responsive to the subpoena. For the past several months, counsel for Mr. Combs have had regular discussions about what documents we had, what we did not have, and in regard to the documents we did not have, where the government may be able to find such documents. We did this for 2 reasons. First, there was nothing in counsel's estimation that would constitute evidence of Mr. Combs being involved in any federal crime. Second, we wanted to be appropriately helpful to the government in its investigation. To that end, the Combs entities have produced over 144,000 pages of documents to the Southern District of New York in compliance with the subpoena. Now, 6, paying off the mortgage at 2 West Star Island in Miami, the same place where Epstein had a home. As noted in the discussions about the bail package, on August the 20th, 2024, Mr. Combs caused the outstanding mortgage to be paid on his primary residence in Miami. This payment of about $18 million was for one reason alone, so that he would have this $48 million residence free and clear of any encumbrances so that it can be used to secure a bond. We submit this is a truly extraordinary measure that shows resoundingly that Mr. Combs is appropriately focused on defending this case on the merits in this court. Now, legal standard. Because Mr. Combs is presumed to be innocent, the Supreme Court has observed that liberty is the norm and detention prior to trial or without trial is the carefully limited exception. And of course, they give some examples like United States versus Salerno, as the Supreme Court recognizes the function of bail is limited in the case of Stack versus Boyle. The underlying goal is securing the presence of the defendant rather than the sum of bail. United States versus Nebbia. When deciding an issue of pretrial release, the Second Circuit has noted that the court should bear in mind that it is only a limited group of offenders who should be denied bail pending trial. United States versus Shakur. Yeah, the United States versus Shakur. Indeed, the Bail Reform Act requires that the court impose the least restrictive condition or combination of conditions that will reasonably assure the appearance of the person as required and the safety of the community. While there is a presumption of detention in sex trafficking cases, this presumption is rebuttable all bold. And again, generally in cases involving sex trafficking, defendants don't get a bond. They are usually remanded. No bail or bond is even issued or even allowed. Now, the presumption imposes on the defendant a burden of production, while the burden of persuasion remains with the government. The United States versus Mercedes is another case example here. Although this burden is not heavy, the defendant must introduce some evidence contrary to the presumed facts. Example of the United States versus Rodriguez. A defendant can satisfy this burden by coming forward with evidence that he does not pose a danger to the community or a risk of flight. Even if the defendant presents some evidence satisfying his or her burden, the presumption favoring detention does not disappear entirely, but remains a factor to be considered among those weighed by the district court. In Jessup, the benchmark case defining that burden shift, the court explained, since the presumption is but one factor among many, its continued consideration by the magistrate does not impose a burden of persuasion upon the defendant. And since Congress seeks only consideration of the general drug offender flight problem, the magistrate or judge may still conclude that what is true in general is not true in the particular case before him. He is free to do so and to release the defendant as long as the defendant has presented some evidence and the magistrate or some judge has evaluated all of the evidence with Congress's view of the general problem in mind. Now, acknowledging that sex trafficking has a rebuttable presumption of detention, meaning generally when charged with trafficking, with sex trafficking, it is presumed that defendants will be remanded without bail. They will be remanded and detained, right? Mr. Combs can rebut such a presumption with evidence that he does not pose a danger to the community and is not a risk of flight. An analysis of the section 3142 factors weigh in favor of releasing Mr. Combs on these conditions. Now, the nature and circumstances of the offense. Mr. Combs is charged with a 3-count indictment. The first count charges Mr. Combs with a racketeering conspiracy in violation of 18 U.S.C. 1962, count 1. Count 1 alleges that Mr. Combs relied on the employees, resources, and influence of the multifaceted business empire that he led and controlled, creating a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice, and that the conspiracy lasted from at least in or about 2008, though on or about the filing of this indictment. As alleged, the pattern of racketeering consisted of A, multiple acts involving kidnapping in violation of California law, B, multiple acts of arson in violation of California law, C, multiple acts involving bribery in violation of California law, and D, multiple acts indictable under 18 U.S.C. 1512 relating to tampering with a witness, victim, or an informant. E, multiple acts indictable under 18 U.S.C. 1589 and 2 relating to forced labor. Multiple acts indictable under 18 USC 1591 and 2 relating to sex trafficking. Multiple acts indictable under 18 USC 2421, 2422, and 2 relating to transportation and inducement to travel for purposes of prostitution and other illegal sexual activities. And F, multiple offenses involving the possession with intent to distribute or distribution of narcotics and controlled substances, including cocaine, oxycodone, alprazolam. These, a lot of these famous drugs, right, that we're just kind of hearing today about, their actual names, but MDMA. This included MDMA, GHB, ketamine, distribution and possession with intent to distribute and conspiracy to commit the same, aiding, abetting, and willfully causing. Indictment 13, count 1 also includes a notice of special sentencing factor in connection with Mr. Combs' alleged agreement that means of force, threats of force, fraud, and coercion would be used to cause the person to engage in a commercial sex act. The second count charges Mr. Combs with sex trafficking by force. And remember, you all, this wasn't state to state, only in the United States. In the indictment from the grand jury, it is alleged that Diddy was doing this internationally. These FreakOffs and forcing, people to travel to attend and, these elaborate productions that he would produce. These things were happening internationally. Count 2 alleges that from at least in or about 2009 up to and including in or about 2018, Mr. Combs recruited, enticed, harbored, transported, and maintained a person, victim 1, and attempted, aided, and abetted, and willfully caused victim 1 to engage in commercial sex acts, knowing and in reckless disregard of the fact that victim 1 was engaging in commercial sex acts as a result of force, fraud, and coercion. Now, again, it is being assumed pretty safely that victim 1 is referring to Cassie. The third count charges Mr. Combs with transportation to engage in prostitution. Count 3 alleges that from in or about 2009 up to and including in or about this year, 2024, Mr. Combs transported, aided, and abetted and willfully caused the transportation of female victims and commercial sex workers in interstate and foreign commerce on multiple occasions with the intent that they engage in prostitution. And then, of course, the indictment also include forfeiture allegations. Now, the defendant's history and characteristics. Mr. Combs' history and characteristics are best demonstrated by the way he has responded to this investigation from the very inception to his most recent decision to travel to New York when his lawyers told him that the case could soon be starting. He has never run from a challenge, and he will not run from this one. Instead, he takes these challenges head on. He moves toward them confidently and with the assurance that right is on his side. These are not merely the words of his lawyer, rather the actions of Mr. Combs over the last several months conclusively prove this. You think the judge is going to buy this, guys? Aside from his actions, since the inception of the investigation, Mr. Combs' character is shown through his demonstrated contributions to society in several important areas. First, he has given generously over his entire life to charitable causes. To name only a few examples, since founding Bad Boy Entertainment in 1993, Mr. Combs has actively supported and donated millions to after-school programs and organizations like the Boys and Girls Clubs of America. His commitment stems from the positive influence such programs had on his own childhood, inspiring him to give back to similar initiatives. He has also supported organizations, including the National Foundation for Teaching Entrepreneurship, further emphasizing his dedication to creating opportunities for young entrepreneurs. A cornerstone of his philanthropy is education, and he fulfilled a lifelong dream when he, with a partner, opened Capital Preparatory Harlem Capital Charter School in 2016 to provide high-quality education to inner-city youth in New York City. The success of this initiative led to the launch of Capital Preparatory Bronx Charter School in 2020, with Combs donating $1 million to support its development. These schools are part of his broader commitment to education, which includes significant contributions to historically Black colleges and universities, such as $2 million to Howard University and $1 million to Jackson State University in 2023. Mr. Combs has also been proactive in health and disaster relief efforts, having raised over $2 million for New York City public schools and hosting a virtual dance-a-thon that raised more than $4 million to provide personal protective equipment to healthcare workers on the front line of the COVID-19 pandemic. Particularly important in an election year is Mr. Combs's contribution to mobilizing young voters with the Vote or Die slogan through Citizen Change, which he founded to significantly increase political awareness and youth voter turnout. Second, few people have done more to advance the cause of Black people in the music, entertainment, and fashion industries than has Sean Combs. While he has always been controversial, he has also always championed minorities and underrepresented communities. As chairman of Combs Global, Mr. Combs has used his platform to create the Excellence Program, an internship initiative with Endeavor in July 2021, a major initiative designed to provide development opportunities for aspiring executives in entertainment, marketing, music, and fashion from underrepresented communities. Mr. Combs's philanthropic work has earned him numerous accolades throughout his career, including the Triumph Award from the National Action Network 2016, the Superhero Award from Room to Read in 2017, the Child of America Award from the Carver Foundation in 2018, and in 2023, the Icon Award from the Apollo. Well, the mayor in New York got the key to the city back. You think anyone else is going to rescind any of these awards that they gave? Especially in the same years that these crimes, were allegedly taking place. Now, council will be prepared to address the factors of dangerousness to the community and weight of the evidence in court at the 2:30 p.m. initial appearance. And again, he's in court. He's absolutely appeared in court again, but we're looking at the letters that were sent, that the judge has received from both the prosecution and the defense. Now, the proposed bail package addresses any issues with flight and danger to the community. In light of the proposed conditions, the actions Mr. Combs had already taken regarding the investigation and Mr. Combs's lifetime commitment to live up to his obligations concerning every challenge he has ever faced, he should be released to fight this case in court and prove his innocence. Remember, Diddy also told us that he had never put his hands on Cassie, and then that video dropped, right? So in my opinion, I don't think Diddy is a very honest person. I'm just saying. His lawyers are talking for him right now, though, right? As they should. Sean Combs has never evaded avoided, eluded, or run from a challenge in his life. He will not start now, as he has handled every hardship. He will meet this case head on. He will work hard to defend himself, and he will prevail. Recognizing that a bail hearing is not the time to defend the merits of a criminal case, it is relevant to bail that the defendant has made a clear commitment to defend an eminently defensible case. This is such a case. Finally, several courts in this district have recognized that the conditions at Metropolitan Detention Center in Brooklyn are not fit for pretrial detention. Just earlier this summer, an inmate was murdered. At least 4 inmates have died by suicide there in the past 3 years. Numerous courts in this district have raised concerns with the horrific conditions of detention there, describing the conditions at MDC as dreadful and long-standing, and noting that the issues with food contamination and hazardous physical conditions were an ongoing tragedy. Describing the MDC as dirty, infested with drugs, and plagued by violence. Describing overcrowding, staffing issues, and lockdowns. Disgusting and inhuman as anything I've heard about any Colombian prison, but more so because we're supposed to be better than that. Courts in the Eastern District of New York have shared the same concerns. The court noted it was worried about MDC's conditions as one of the reasons for sentencing the defendant to a non-custodial sentence. These are different case examples, right? Sentencing a defendant to 9 months in prison, but ordering that if BOP designated the defendant to the MDC, the court would vacate the sentence and resentence to home incarceration. In conclusion, for the reasons set forth above, we moved this court to release Combs under the conditions set forth above. Thank you for your consideration. Respectfully submitted, Mark Agnifilo and Tony R. Garagos, who, by the way, is the daughter of famous attorney Mark Garagos. And then you see here in the footer, there's links and to some of these incidents that have happened at MDC. All right, let's take a look at the prosecution's request. So this was, wow, look at this, you all. Look at this. Defaced serial numbers. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet. Stored, broken down in parts. I mean, just look at this, right? They've got pictures in their letter to the judge. But hey, let's hit it, right? Let's hit it. This is the United States Attorney, Southern District of New York's letter to the Honorable Robin Tarnofsky, United States Magistrate Judge, right? Did he do it? Did he, no Diddy? Dear Judge Tarnofsky, the defendant Sean Combs, aka Puff Daddy, aka P. Diddy, aka Diddy, aka PD, aka Love, was taken into custody this morning after a grand jury sitting in this district returned a 3-count indictment charging him with crimes related to his decades-long pattern of physical and sexual violence against multiple victims and his use of force, threats, and coercion to enact his will, protect his reputation, and fulfill his sexual desires. The government respectfully submits this letter in anticipation of the defendant's appearance before this court later today, and in support of the government's request for the defendant's detention pending trial. As set forth below, there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. As reflected by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight, despite the conditions offered by his counsel. Most glaringly, the defendant also poses a significant risk of obstructing justice. Indeed, as set forth below, during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened and interfered with witnesses to his criminal conduct. He has already tried to obstruct the government's investigation of this case, repeatedly contacting victims and witnesses and feeding them false narratives of events as described in detail below. There are simply no conditions that would ensure that the defendant's efforts to obstruct and tamper with witnesses will stop. The defendant, therefore, cannot overcome the statutory presumption in favor of detention, and the court should order him detained. Again, prosecution's very clearly saying, they want him remanded. What's up with it, Nesbitt? Good to see you. I don't know. So it looks like somebody got banned. I don't know what the heck name that is. But yeah, this is a serious live, guys. This is a serious live, right? Anyway, shout out to my mods. Shout out to those of you in the chat. You know, let's just woo-saw for a second here. I mean, we just read Diddy's case and his bail package, right? He's offering up $50 million. And basically what he's offering up is his $48 million mansion, or what has been appraised at $48 million, and his own mama's house. His own mama's house. On September 17, 2024, an indictment returned by a federal grand jury sitting in the Southern District of New York. The indictment was unsealed, charging the defendant with racketeering conspiracy from in or about 2008 through on or about the date of the indictment. And shout out to you behind the bar. Good to see you. In violation of count 1, sex trafficking from in or about 2009 through in or about 2018. Count 2, interstate transportation to engage in prostitution from in or about 2009 through in or about 2024, in violation of 18 U.S.C. 2421 and 2. That's for count 3. A, Combs's use of violence, threats, and coercion. Since at least 2008, the defendant and other members and associates of the racketeering enterprise alleged in the indictment, which includes the defendant's multifaceted business empire, wielded the power and prestige of the defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes, including racketeering, sex trafficking, and other offenses. As charged in the indictment, many of those crimes involved the sexual abuse and exploitation of women and other crimes of violence. 1, sex trafficking and abuse. Using the power and prestige of the enterprise, the defendant, who is Sean Diddy Combs, lured female victims into the defendant's orbit, often under the pretense of a romantic relationship. The defendant then used force, threats of force, and coercion to cause those female victims to engage in sexual activity which included frequent sex acts with male commercial sex workers that the defendant referred to as FreakOffs. FreakOffs were elaborate sex performances that the defendant arranged, directed, masturbated during, and often electronically recorded. FreakOffs occurred regularly from at least in or around 2009 through this year. Sometimes lasted multiple days and frequently involved multiple sex workers. The defendant arranged freak-offs with the assistance of members and associates of the enterprise, including employees of his business, and the hotel rooms where they were staged often sustained significant damages. The defendant ensured the victims would participate in freak-offs through coercion and violence. For instance, the defendant provided controlled substances, including ketamine, ecstasy, GHB, to female victims so that they could and would continue to engage in freak-offs. Despite fatigue, physical, and emotional exhaustion and pain. Additionally, both during freak-offs and separate from freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse, in part to cause them to engage in freak-offs. The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and or the injuries sustained by women at the defendant's hand. One incident of physical abuse occurred when a female victim was attempting to leave the hotel following a March 2016 freak-off. This abuse was captured on video surveillance and publicly reported in May of 2024, and they are referring to the video of him beating Cassie. The defendant's assaults often resulted in serious injuries to the victims that took days or weeks to heal. Just as an example here in the footer, notice this. For example, in approximately 2012 in Manhattan, the defendant, Diddy, Sean Combs, paid over $46,000 to cover damages to a penthouse hotel room following a freak-off. An excerpt of this video footage is attached as Exhibit A. Ouch. Ouch. I think that's going to hurt. Remember when I told you all that Lil Rod, the producer that worked for Diddy for about a little over a year? He said he has hundreds of hours of incriminating video and audio. Why? Because narcissist Sean Diddy Combs wanted him to record everything. Just note that. The defendant also coerced victims into participating in freak-offs by controlling their careers, finances, livelihoods, and or housing, among other aspects of their lives, or by threatening to disseminate recordings of freak-offs. The defendant used his considerable wealth and influence to make victims rely on him financially. For example, by paying for their rent or their cars, or by offering them career opportunities. Once he provided his support, the defendant repeatedly threatened to take it away to ensure the victim's compliance with his demands, including their participation in freak-offs. Indeed, victims believed that they could not refuse the defendant's demands, that they engage in freak-offs without risking their financial security or career prospects, or without repercussions in the form of physical or emotional abuse. Other violence. 2. In addition to the defendant's physical, sexual, and emotional abuse of his romantic partners, the defendant repeatedly engaged in acts of violence directed towards his employees and others. As charged in the indictment, the defendant, often assisted by members and associates of the enterprise, engaged in kidnapping, arson, and physical violence, such as throwing objects at people, throwing people to the ground, and hitting, dragging, choking, and shoving others. Numerous witnesses, including the defendant's employees and others, observed or experienced violence from the defendant firsthand and sustained lasting trauma as a result. For example, in the early morning hours of December 22nd, 2011, the defendant and a co-conspirator kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another individual, individual 1. Multiple witnesses would testify at trial to the events surrounding the kidnapping and break-in, the latter of which is corroborated by police records and police reports and other records. Approximately 2 weeks later, the defendant's co-conspirators set fire to individual 1's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior. Police and fire department reports extensively document the arson and conclude that the fire was intentionally set. Multiple witnesses would also testify to the defendant bragging about his role in destroying individual 1's car. That part, Donnie. Cough, cough. Kid Cudi. Kid Cudi. More broadly, since at least 2008, allegations of the defendant's physical abuse of women and others have been publicly reported in the media, including in Hollywood blogs and on podcasts. Law enforcement reports corroborate that police responded to several instances of the defendant's violence, including assaults against victims and other individuals. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical and sexual violence dating as far back as the 1990s. In short, the defendant's violent tendencies are widely known. However, at no point during the past few decades has the threat of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. 3, firearms. The defendant and members of the enterprise, including the defendant's security personnel, at times carried firearms, and the defendant himself carried and brandished firearms to intimidate and threaten others. Indeed, some victims were aware of the defendant's access to firearms. On one occasion, the defendant forced a female victim to carry a firearm on his behalf, and on another occasion, he pointed a firearm at a female victim. Let's also just add, this is just a note from LeakYou. You remember Shine, right? And the whole episode that he went away for 10 years for? He's always said that it was really Diddy that pulled that trigger and blew that woman's face off. But he was never prosecuted for it. Now, the defendant continues to have access to guns, including illegal firearms. In March of 2024, during searches of the defendant's residences in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s, each with a defaced serial number, as well as a large capacity drum magazine. As pictured below in a close-up image, the serial number of one of the AR-15s is visibly bored through and obscured. They call those ghost guns. That's right, Def Chep. The woman that was shot also stated it. You're correct. You are absolutely correct. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet, stored broken down in parts, along with magazines that were loaded with ammunition, as depicted below. One of the AR-15s had a 10 round magazine loaded with 10 rounds of large caliber 223 ammunition, while the second AR-15 had a 30 round magazine loaded with 19 rounds of 223 ammunition. As you can see here, it is a very large caliber. A large capacity drum magazine loaded with 59 rounds of 223 ammunition was seized from the defendant's Los Angeles residence. So he had guns in both of his homes, the one in Miami and the one in California. In addition, 6 legally purchased guns with serial numbers, some of which were stored in gun safes, were recovered from the defendant's residences. Although these particular guns, both the legal and illegal firearms, were seized, their presence in the defendant's homes demonstrates that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendant were personally restrained by the court from obtaining new firearms himself, he could retain access to them through others. In sum, the defendant's regular use of violence and threats of violence, as well as the coercion described above against the victims and others, fostered a culture of fear in which these individuals believed they were unable to reject the defendant's demands without subjecting themselves to physical violence or other abuse. Now, check this out. We want to read this little footer here. Certain of the firearms seized during the March 2024 searches were licensed to a current member of Combs's security staff. In addition to that individual, during the course of the charged conspiracy, Combs has employed other security staff members with significant criminal history, including violent crimes and firearms offenses. Now, remember in the video we just did, I said, what about the guns? Why are the guns being put on display during this press conference? Because the district attorney wants to show Diddy as being a violent person. Think about what a judge is going to think when he sees this in notes. Man, why are the serial numbers filed off these guns? It shouldn't be illegal to own an AR-15. Combs bribed witnesses and obstructed justice. Throughout the time period charged in the indictment, when the defendant faced the possibility that his violent and criminal conduct could become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they saw or heard to law enforcement, or to otherwise conceal the criminal conduct. For example, and as noted above, in March 2016, the defendant was captured on video surveillance striking, kicking, and dragging a woman in a public area of a hotel in an apparent attempt to prevent her from leaving a freak off. Talking about Cassie, that video that we all have seen. Preventing her from leaving a freak off. When a member of hotel security staff intervened, the defendant attempted to offer the hotel security officer a stack of cash to ensure his silence. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employees, the defendant's staff contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel's server. Somebody had it because CNN dropped it, right? Similarly, throughout the time period charged in the indictment, members and associates of the enterprise have reached out to multiple victims on behalf of the defendant to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of the defendant's crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events in an apparent effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. Now, how would the prosecution know about these recordings if they ain't got said recordings? C, the government's investigation is still ongoing. While the indictment against the defendant was unsealed today, the investigation into his and other co-conspirators' conduct is active and ongoing. As a result of that ongoing investigation, as well as the defendant's charged conduct outlined above, including obstruction of justice and witness tampering, the government is limited in its ability to fully set forth all known details of the defendant's criminal conduct, including details of certain witness testimony. To the extent the court has additional questions about the charged offense conduct or any other information set forth herein, the government is prepared to proffer additional information on an ex parte basis. So essentially in this letter, a finding of risk of flight must be supported by a preponderance of the evidence. A finding of dangerousness must be supported by clear and convincing evidence. Obstruction of justice is another ground for pretrial detention by the courts. And again, they're giving examples of various cases that support their side, right? Thank you, Jay. Thank you. Courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish by clear and convincing evidence that there exists a serious risk. The defendant would threaten, injure, or intimidate a prospective witness or juror. Again, these are case examples. The Bail Reform Act lists 4 factors to be considered in the detention analysis. 1, the nature and circumstances of the crimes charged, including whether the offense is a violation of Section 1591. 2, the weight of the evidence against the person. 3, the history and characteristics of the defendant, including the person's character, past conduct, and financial resources. And 4, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. The concept of dangerousness encompasses not only the effect of a defendant's release on the safety of identifiable individuals, such as victims and witnesses, but also the danger that the defendant might engage in criminal activity to the detriment of the community. A finding of dangerousness does not require that the defendant have criminal history, particularly if a defendant has a history of domestic violence. Holding that prior acts of domestic violence are relative to a determination of dangerousness because a willingness to strike loved ones offers probative evidence of tendency to violence and dangerousness towards others. Evidentiary rules do not apply at detention hearings, and the government is entitled to present evidence by way of proffer, among other means. Government entitled to essentially proceed by proffer in detention hearings, and again is providing case examples. where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, such judicial officer shall order the detention of the person before trial. Additionally, where, as here, a defendant is charged with sex trafficking in violation of 18 U.S.C. 1951, in other words, an offense under Chapter 77 of Title 18, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. For the reasons set forth below, the defendant poses a significant danger to the community, both in terms of physical violence and obstructive conduct, as well as a risk of flight. This is especially true given the nature of the criminal conduct and the strong weight of the evidence. The defendant, therefore, cannot overcome the statutory presumption in favor of detention in this case. Dangerousness. The defendant is charged with serious and violent crimes. As charged in the indictment, the defendant has physically and sexually abused women and others for the better part of 2 decades. The sex trafficking charge, based on the defendant's abusive conduct, count 2, carries with it a presumption of detention, meaning it is presumed that you would be detained if you were charged, particularly count 2. And detention is particularly supported by the facts of this case. Since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including sex acts with commercial sex workers, by using physical force, financial pressure, emotional abuse, and narcotics. These acts, described in detail above, were referred to as FreakOffs, among other names, and involved orchestrated sexual performances facilitated through drug use that sometimes lasted days at a time. That is not all. As set forth in the indictment, the charges against the defendant capture significant additional violence, both spontaneous and premeditated. On numerous occasions, the defendant assaulted women, employees, and others when he became enraged. By throwing objects at them, choking them, pushing them, kicking them, and slamming them against walls and onto the ground, the defendant and other members and associates of the enterprise were also capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. The defendant's violence, whether spontaneous or premeditated, had the effect of exerting his continued control over these individuals. The defendant also carried firearms to intimidate and threaten others. Multiple defaced semi-automatic rifles were recovered when law enforcement searched the defendant's residences in March of 2024, including 2 defaced rifles that had been disassembled and hidden in the defendant's bedroom closet. In short, the conduct with which the defendant is charged shows a pattern of violent and abusive conduct, underscoring his dangerousness. This disposition to violence cannot be reasonably prevented through bail conditions. The violence alleged in the indictment was not isolated or aberrational. It was systematic and pervasive. The defendant abused women with whom he was in personal relationships, employees, witnesses to his crimes, and others. As described above, the defendant has sexually, physically, and emotionally abused long-term romantic partners for decades, including by forcing them to engage in freak-offs The defendant has abused countless others in his orbit, and in particular women, without regard for consequences. Indeed, the defendant's abuse of women long predates the conduct charged in the indictment. To date, at least 5 women have publicly accused the defendant of violent sexual assaults dating back to the 1990s. Moreover, the defendant's violence and abuse often occurred behind closed doors, including in his homes, hotels where he was staying, and other private settings. He has assaulted victims, employees, and others, and even brandished a firearm at a victim in his homes. The alleged sex trafficking similarly took place in private settings not easily monitored. Again, you all, this was international, and it was mentioned in the indictment. This wasn't just, state to state to state. Diddy was having these freak-offs in procuring these sex workers for commercial sex acts, and this was going on internationally, meaning across the world, different places in the world. The alleged sex trafficking similarly took place in private settings not easily monitored. Indeed, in addition to engaging in freak-offs at hotels, the defendant has at times organized freak-offs at his home or at the homes of his female victims. This is precisely the kind of violence that even strict conditions such as home incarceration cannot prevent. In sum, the defendant's long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure the safety of the community. The defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own sexual gratification. And uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. See 18 U.S.C. 3142. The defendant's long-standing pattern of abuse is probative evidence of the likelihood that he will continue to abuse. Indeed, nothing, not even the threat of public exposure or law enforcement intervention, has stopped his abuse. The defendant has continued to physically assault and threaten those around him, including his romantic partners, his employees, and others who happened to be present when he succumbed to fits of rage. No bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse or assault, and the defendant's physical assaults are serious, resulting at times in serious injury requiring medical intervention and long periods of recovery. Therefore, the nature and seriousness of the danger to any person is both real and specific. Obstruction. As part of the charged racketeering conspiracy, the defendant engaged in obstruction of justice, including bribery and witness tampering. Given the defendant's history of engaging in obstructive conduct to conceal his criminal activity, both personally and through intermediaries, there is every reason to believe that the defendant will continue to engage in such obstruction if released. As detailed in the indictment, following a freak-off in March 2016, the defendant attempted to bribe hotel security staff to prevent hotel security from publicly disclosing and/or reporting to law enforcement his vicious attack on a woman attempting to leave a freak-off. Again, we believe this is referring to Cassandra Ventura. The defendant's efforts to disclaim responsibility for that attack continued until earlier this year. A civil lawsuit was filed on or about November 16, 2023, alleging years of sexual, emotional, verbal, and physical abuse by the defendant, including allegations describing the March 2016 incident. Following the filing of the lawsuit, the defendant stated in no uncertain terms, quote, "Let me be absolutely clear. I did not do any of the awful things being alleged," end quote. Through counsel, the defendant vehemently denied these offensive and outrageous allegations, describing the complaint as riddled with baseless and outrageous lies. What's up, Cuban Crisis? It was not until the video surveillance footage of the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had, in fact, perpetrated the disgusting attack. Clearly, the defendant is willing to deflect, minimize, and lie, and induce others to do so on his behalf to avoid taking responsibility for his own actions. More recently, the defendant has directly and through intermediaries engaged in obstructive conduct related to the matters under investigation in this case. Specifically, following the November 2023 lawsuit, the defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoken to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in efforts to protect the defendant. For example, on or about November 19th, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to another victim of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and friendship and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she needed the defendant too, she ain't got worry about nothing else. A thinly veiled attempt to coerce the victim into adopting and supporting the defendant's false version of events to protect the defendant. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrants at his residences, Combs contacted other witnesses on multiple occasions, including other witnesses who had received grand jury subpoenas. The defendant's recent conduct is similar to that in the United States versus LaFontaine, in which the Second Circuit affirmed the district court's revocation of pretrial release after the defendant in that case engaged in witness tampering. Specifically, the defendant, who was charged with multiple counts of fraud in connection with providing false claims to medical insurers, called a witness to remind the witness that a particular patient had received surgeries that the patient had not, in fact, received. The Second Circuit affirmed the district court's finding that there was no condition or combination of conditions that would assure the safety of the community, given the defendant's witness tampering, despite the fact that the defendant's tampering did not include actual violence or threats of violence. And the prosecution goes on to list several articles here, including Billboard, CNN, and a YouTube video. It's an AP YouTube video that showed from the defendant's account in which the defendant admits to the attack depicted on surveillance video. The shitty apology that Diddy gave the world. Again, that apology was subsequently deleted from his Instagram account. Now, here the defendant's conduct goes beyond what the LaFontaine court found sufficient to revoke bail. Even before being charged with the crime, the defendant has taken numerous proactive steps to tamper with potential witnesses' testimony against him. The government is aware through electronic evidence, toll records, conversation with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witnesses were required to appear before the grand jury. In addition, the defendant has recorded calls with at least one victim and provided either directly or through intermediaries false narratives of the events that transpired so that those witnesses would adopt that false testimony. Moreover, the defendant's obstructive conduct is made even more alarming by the manner in which he carried it out to evade detection. In some instances, by having intermediaries make calls on his behalf and recording certain calls on another individual's device. These deliberate actions show that the defendant was aware that what he was doing was obstructive and that his aim was to evade detection. Even the most stringent conditions, including the monitoring of a court-authorized electronic device, would fail to ensure that the defendant would not engage in this kind of obstruction from his home, including by acting through intermediaries and using others' devices. Given the defendant's history of obstruction, as well as the violent nature of the charges against the defendant cannot overcome the presumption that no condition or combination of conditions can assure the safety of the community. Risk of flight, nor can the defendant overcome the presumption that he is a risk of flight. The crimes that the defendant is charged with carry significant penalties, including a mandatory minimum sentence of 15 years imprisonment and a statutory maximum sentence of life imprisonment. The possibility of a substantial sentence is a significant factor in assessing the risk of flight. The steeper the potential sentence, the more probable the flight risk is, especially considering the strong case of the government. Here, the defendant is facing at least 15 years imprisonment if he is convicted. This fact alone would provide a compelling incentive for anyone to flee from prosecution. But the incentive to flee is especially strong for this defendant, who at age 54 faces the very real prospect of spending a substantial portion of the rest of his life in prison. As detailed below, the evidence in this case is incredibly powerful, as the facts set forth in the indictment and herein make plain. Dozens of victims and witnesses have provided detailed, credible, and corroborated information against the defendant. These individuals include many who personally experienced and witnessed violence and other crimes at the hand of the defendant. Again, I must add this. Little Rod's civil lawsuit and the hundreds of hours of video and audio that he alone has. Why? Because Diddy, Sean Combs, demanded that he record everything. And from what Little Rod has put in his civil lawsuit against Diddy, is that on many of these recorded, pieces of video, it's incriminating. It's absolutely incriminating. For example, moreover, their accounts are well corroborated by significant extrinsic evidence, including financial and billing records travel records, electronic data, and communications. I mean, if you really pay attention, the government is telling you that they have financial records. They've got billing records. They've got travel records. They have certain electronic data that is heavy for Diddy. And communications, including extensive communications by and with the defendant himself. For example, victim testimony regarding FreakOffs is at times corroborated by other witness testimony, communications with the defendant and commercial sex workers, travel records, hotel records, videos of the FreakOffs, and records reflecting or indicating payment. The government is telling us they have this type of evidence. Similarly, a victim's physical abuse may be corroborated by, among other things, videos of the abuse, photographs of injuries, reports made to law enforcement, communications with the defendant and others, and testimony from other witnesses who saw or heard about the abuse. The vast and varied sources of abuse described in detail below will be compelling evidence of guilt at any trial in this case. Thus, the serious risk of conviction provides further incentive for the defendant to flee prosecution. Moreover, in this case, risk of flight is augmented by the nature of the evidence against the defendant. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For example, dozens of video recordings created by the defendant of FreakOffs with victims. That sentence weighs heavy, you all. The government is pretty much telling us that they have dozens of video recordings that were created by Sean Combs himself. So I wonder, when they went into his homes, did they find his stash of videos? Because the government is saying here that they have serious, substantial evidence, highly sensitive evidence. For example, dozens of video recordings created by Sean Combs of FreakOffs with victims. For decades, the defendant has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee to avoid prosecution and a public trial. The defendant's incentive to flee outlined above, coupled with the defendant's seemingly limitless resources, create significant risk of non-appearance. The defendant's net worth is publicly estimated at being close to $1 billion. Indeed, the investigation of this case has revealed that the defendant has access to vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. At least as of December 2023, the defendant had access to dozens of bank accounts, some personal, and many under corporate entities, which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. The defendant maintains 2 primary residences in Los Angeles and Miami. In addition to his private plane, the defendant owns multiple vehicles in multiple locations. He has personal staff, including assistants, security, chefs, trainers, and others who perform tasks at his command, including transporting him, delivering him currency, securing narcotics for him. And he is extraordinarily well connected both within and outside the entertainment industry. In short, if the defendant wanted to flee, he has the money, manpower, and tools to do so quickly and without detection. The defendant's lack of access to his passport or private jet would not negate the fact that the defendant could easily buy his way out of facing justice. As discussed below, the defendant's legal team has attempted to mitigate this substantial risk of flight by taking steps such as taking his family's passports, attempting to sell his plane, and reporting his whereabouts to the government. These steps have been taken with the precise goal of crafting an argument for bail before the court. While the defendant may have made the calculated decision in consultation with his attorneys not to flee before any charges were filed, that calculus inevitably changes today when an indictment charging the defendant with extremely serious offenses carrying enormous potential penalties was unsealed. He is now, for the first time in his life, facing a mandatory minimum term of imprisonment of 15 years and a maximum term of imprisonment of life, in which the government is prepared to prove the charges against him by, among other things, the testimony of dozens of witnesses and victims to his serial abuse and evidence from dozens of his own electronic devices and those of his co-conspirators. Ouch. Ouch. Given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it ever has been. Now, what about the weight of the evidence? In considering the danger and risk of flight presented by the defendant, the court is also required to consider the weight of the evidence against the defendant. The defendant faces a strong and powerful case here, only magnifying the danger he could present to others, especially victims and witnesses ready to testify against him, and the risk he flees. The evidence in this case consists of a vast amount of victim and witness testimony, electronic evidence, physical evidence, and subpoena returns and other voluntary productions, among other things. As to witnesses, to date, the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. Now listen close to this here. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses, setting aside devices seized in connection with the defendant's arrest. Listen to this, y'all. The government has obtained over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and a surveillance system. This electronic data comes from the defendant himself, as well as co-conspirators victims, and witnesses, and chronicles much of the defendant's criminal activity as it occurs. Who saw on that for a minute? Government is telling us they have over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices, including hard drives, thumb drives, cameras, and a complete surveillance system. And they're saying here that a lot of this electronic data comes from who? None other than Sean Diddy Combs, aka Puff Daddy. His own narcissism may be his downfall. The evidence also consists of physical evidence, which was seized pursuant to search warrants executed at the defendant's residences in Los Angeles and Miami, as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of FreakOffs. Listen to this. Including over 1,000 bottles of baby oil and personal lubricant. Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 1,000 entities and individuals, including communications providers, tech companies, social media companies, banks, and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firm. Together, this evidence, as well as other evidence gathered, powerfully demonstrates the defendant's guilt and counsels in favor of detention. Yes, LeakYou.com, 1,000 bottles of baby oil and personal lubricant, not to mention the IV fluids that were given to some of these victims and to Sean Combs himself after these freak-offs, because they were so physically intense that they would last days at a time. So prosecution is saying that the defendant's proposed bail package is just insufficient. And they go on to say that for all the reasons set forth herein, there is no bail package that can reasonably assure the safety of others in this case, where the defendant has engaged in a decades-long pattern of violence against women and others, and has used his wealth and power to ensure that his criminal conduct goes unpunished through manipulative and obstructive conduct. In particular, the bail package proposed by defense counsel is insufficient because it fails to adequately protect others from the defendant's violence, impose measures to prevent and detect obstruction, or prevent the defendant from accessing his vast resources, including millions of dollars in cash, to evade prosecution, or dissipating those assets to avoid financial penalties for his crimes. Defense counsel has proposed certain bail conditions, including home detention with electronic monitoring and a $50 million bond secured by the defendant's Miami property. These conditions are plainly insufficient to address the legitimate concerns set out above. In particular, given the defendant's history of engaging in obstructive conduct, the court must reject the insufficient conditions proposed by defense counsel, which do nothing to prevent and detect such conduct. And again, they give an example of a case in which the defendant was charged with witness tampering and where obstruction remained an ongoing concern. The Second Circuit reversed the district court's release of the defendant on bail conditions because the $1 million bond, which was to be secured by properties that were owned by the defendant and members of his family, only deterred flight, not danger. More specifically, the Second Circuit found the district court's bail condition intended to address witness tampering, which was a general prohibition that the defendant was not to commit a crime or intimidate a witness, does not at all impede his ability to do so and requires no more of him than that which the law already demands from a defendant and every other citizen. Notably, the defendant's previously proposed conditions do not include provisions related to his access to electronic devices, which, as outlined above, the defendant uses to engage in obstructive conduct. Nor do the proposed conditions include information related to or restrictions on access to the defendant's vast resources, including multiple personal bank accounts in the name of the defendant's business, and deep cash reserves, which could facilitate the defendant's flight. Similarly, the proposed conditions fail to protect against dissipation of assets, which may be subject to forfeiture or penalties on the charges in the indictment. Finally, the proposed conditions do not include conditions that would limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrender of all firearms. In conclusion, as set forth above, the defendant poses an ongoing and significant danger to the community, has repeatedly engaged in obstructive conduct, and presents a serious risk of flight. The government respectfully submits that the defendant cannot meet his burden of overcoming the statutory presumption in favor of detention. There are no conditions of bail that would assure the appearance and compliance of the defendant or the safety of others. Accordingly, any application for bail should be denied. Look at that. Exhibit A, video exhibit. The fact that they've got all of this evidence against him, right? But here's the deal. He is going to be held without bail, right? The judge has ruled. The judge has ruled, and the judge has denied Sean Combs bail in court. Now, his attorney is going to appeal this, noting that it's going to be a different judge for that particular appeal hearing. But the judge has denied Diddy's bail. He will remain in custody. He will remain in jail. Now, let's just take a moment here. Give me 1 second, folks.
Hey, I'm Hallie, and tonight we are learning in just the last few minutes that a federal judge is now refusing to grant Sean Diddy Combs bail. Instead, he's going straight to jail tonight after Diddy pleaded not guilty to charges of sex trafficking and racketeering. Want to show you some of these brand new court sketches coming into us, like literally in the last 90 seconds. This is Combs in court after prosecutors arrested him at a hotel in Manhattan. It's where he's apparently been living for weeks, according to what a person familiar with the move tells NBC News. All of it a tipping point now in that sprawling federal investigation into the superstar's alleged years of sex crimes dating back to 2009. As we're just getting in some new and deeply disturbing details about the allegations against him and what looks like a massive criminal operation, allegedly. At least 50 victims and witnesses so far. And at the center of it, these hours and days-long sex acts known as, in their words, FreakOffs, that Combs supposedly orchestrated to abuse his victims.
Combs allegedly planned and controlled the sex performances, which he called FreakOffs, and he often electronically recorded them.
Prosecutors say Combs punched and kicked his victims to try to keep them under control. He'd also, they say, filled them up with drugs like ketamine and ecstasy for long periods of times, even using incriminating records to try to manipulate his victims. Prosecutors say they discovered this wide range of evidence against Combs in several raids. They found things, they say, like AR-15s, narcotics, more than 1,000 bottles of baby oil and lubricants. We should note here that an attorney for Combs says that he, I'm quoting here, will fight this with all of his energy. His team is already planning to appeal the bail ruling, meaning they will be back in court tomorrow, as Combs has, as we mentioned, pleaded not guilty. We've got team coverage, Laura Jarrett standing by with the legal analysis piece of it. But I want to start outside court with Julia Ainsley, because Julia, this went fairly late into the day. I know you've been at the courthouse as a judge, as we've just learned, is denying this request for bail. Explain why that is and what else we've learned today.
Yeah, that's right. We were in there for about 2 hours as the Justice Department from the Southern District of New York laid out their case, very similar to what you saw in the indictment, saying why he should not be released, because they say that he is a flight risk, he could leave the country, and also that he has a history of obstructing justice. They also pointed to how serious these crimes were, that with previous allegations of sex trafficking like R. Kelly and Jeffrey Epstein, the judges also denied bail in that case. But his defense laid out a very lengthy rebuttal to all of that. We heard them say that this is different from Jeffrey Epstein and R. Kelly because there are no minors being alleged in the indictment here. They also say that these acts were consensual, and they point to victim number one, who's named over and over again, who they say is someone was in a 10-year relationship with Combs that was toxic but consensual. They said that this person actually tried to sell this same story as book rights to Combs to try to get it out of the media's eye, but instead when he refused, then this civil lawsuit came up. But the judge ultimately said that he could not be released because he is a danger, he has a history of substance abuse and anger issues, and she really drilled down on the fact that after those civil allegations came out last November, he talked to multiple women who he knew during that period and who he apparently tried to change their narrative so they wouldn't go forward and continue testifying or being witnesses to some of these acts that were alleged in the civil complaint and then were again put in the indictment today. And so she said in order to keep that from happening and really to end sex trafficking, since that can happen behind closed doors, it was best to keep him detained without bond.
Julia, it is, I think for a lot of folks, they will find this stunning considering that Diddy, right, Sean Combs, has been previously one of the most successful music superstars in the world. Just a year ago, he was handed a key to New York City. Now here we are, after months of this being out in the public, these allegations being made public, his denials, he's potentially facing 15 years to life in prison. What does the timeline look like here?
Well, we understand that tomorrow they'll try to appeal the judge's decision. His defense will do that tomorrow at 3:30. They'll meet again next week for a conference, and then perhaps we'll be looking at a trial early next year. But Hallie, I have to say what you said there was also striking. I mean, I watched him today sitting there very humbly in court in a black T-shirt, nodding along with his defense, otherwise just looking very stoic, straight ahead at the judge. It's hard to imagine this is the same man, but the timeline is also staggering. It's one thing to think, oh, that was something that happened a long time ago. But the prosecution today said that these acts, what they're calling sex trafficking and coercion, all continued up until this year, Hallie, and started as far back as 2009. So this was not a brief window.
Julia Ainsley live for us there outside court in New York. Can you just give a sense really quickly, Julia, before I let you go? Is it just a scene there? I mean, I have to imagine, given who Sean Combs is, it is just a crush of cameras, a crush of people.
It is. It's been really crowded today, and there have been people who've been driving by, sometimes screaming, "Free Diddy." Someone else stood up earlier and said Tupac would be ashamed of Diddy. It's been a lot of people, a lot of public interest here. I will say the court wasn't as crowded as I thought, but still nearly full, and also full of his friends and family who came out.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.
You all. Ooh-wee, what a day, right? Freak-offs, arson, drugs, kidnapping, IV. I still can't get over the IV fluids thing. The fact that they would have these freak-offs for days on end, okay? Days on end. And would need IV fluids to help recover from all the drug use and physical exertion. Could you imagine having sex for days? Talk about tired and in pain. And the fact that they were confiscated over 1,000 bottles of baby oil and sex lubricant. And then again, if you refer back to the video I did earlier today, what did I say? When the feds came a-knocking and kicked in his doors in Miami and Los Angeles, that was icing on the cake. Their goal was to try to see what they could gather so that they could put whatever additional charges they could put upon him. But they already knew what they was going to charge him with. They already had a pretty heavy, solid case, I believe. Again, that the raids on his homes was just icing on the cake. And it sounds like the raids on his homes has also helped to contribute to these charges, including the RICO charge. And also, authorities found electronics. See, they're pretty much saying they got videos of Diddy engaging in these things. They got him. So again, his bail has been denied. His attorney will be appealing, but I highly doubt he will be successful. His attorney must fight vigilantly, right? His own evidence is going to be used against him. Isn't it always that way, Dolly? Yes, they do. And not only do the feds got a very high conviction rate, the truth is they're only going to take a case that they can really seriously convict someone with, right? But the Southern District of New York, the SDNY, is famous for their conviction rate. They are well known for their conviction rates. Gatorade for days. That part. But imagine after a lot of, exertion, hours of exertion like this, imagine how they must have felt like they were hit by a Mack truck. They need IV fluids, Cuban crisis, IV fluids to recover from these. Oh my gosh, that's crazy. Yeah, I think so too. Tila.com says, I'm sure his people knew how to put the IVs on them. Oh yeah. He's got the kind of money that he could have doctors working for him at the snap of his fingers. Okay. So, you all, we have went through a lot of information today. The indictment against Sean Diddy Combs. We read through the indictment that includes sex trafficking, forced labor, kidnapping, arson, bribery, obstruction of justice. And again, I think we went through we got a little additional information from the letters that the prosecutors submitted to the judge, but Kid Cudi and the Molotov cocktail. This is a man who's gotten away with this behavior for decades. And many people my age who was around when he hit the scene was all up in the videos, as Suge Knight said. The producers want to be all up in the videos, right? We have always questioned what role he had in the murder of Tupac Amaru Shakur. Listen, you all, I appreciate each and every one of you for hanging out with me as we went through this. I may be live again later tonight. I've been just reporting on this so much. I need to put some food in my system. And I may have an open panel. I may open up the panel. That's something I normally really don't do. Hey, you're quite welcome. Absolutely, man. I appreciate you all for hanging in there with me. Gloria, shout out to you. Third Eye. I'm sorry if I missed anybody. The 185 behind the bar was up in the building. He said it's over for Brother Love. Def Chef was in the building. Donnie's was in the building. J Snake the Great. Kenna, Cuban Crisis, Mika One. We've had a lot of folks come through today. And again, I think later I may actually open up the panel and have a discussion with others, with some of you. If you're interested, you know, what I'll do is I essentially will drop the link and allow you to come up and, you know, we start vibing, right? We'll just talk about this and bear it out as much as we can. And I don't really typically do panels, right? But I'm kind of interested in what others are thinking right now, especially now that it is official that the judge has denied bond. If his ruling stands, Diddy, Sean Combs, Cuban Christ just threw me off there. Not a lot of cocktail activity. Oh, oh my goodness. So much cocktail activity that, you know, IV fluids were needed to make them feel some kind of level of normalcy. Just throw the key away, right? He did a lot of ish and trying to hide it. What's really going to get him, though, and what the government's sort of bragging on in these documents, is the fact of all of the electronic evidence that they seem to have gotten during these raids. And the fact that they confiscated over 90 cell phones and laptops and cloud storage accounts. He, because of his self-centered narcissism and his requirement that he's recorded daily, every minute of his life is recorded, may be the very thing that gets him that mandatory minimum sentence of 15 years in life. That's what he's facing. He's facing a minimum of 15 years, a maximum of life in prison. And the district attorney has clearly said that this may not be it. This may not be all the charges that come against him, or potentially others. Okay. So with all of that said, I appreciate each and every one of you for coming through. I'll see you all in the next live stream, everybody. Until next time. Shout out to the LeakYou community. Please join us on Spotify, Apple Podcasts, Google Podcasts, and Amazon Music.
Please hit the like. Thank you.
The judgment sentence that you are an asshole. The trial is over. Thank you, everybody.
Let's play a game. You have 10 seconds to take all your stuff and get out of my life. 10, 9, 8.
God bless you, motherfucker.
You're really smart. Like really, really, really smart like I am.